so much. I decided to help the audience and everyone else by trying to find how to say, a version of my name which is understandable in international context as well. So it's not based on the general rules of Hungarian language, but it is understandable outside the Hungarian language as well. So thank you so much. And thank you for the invitation as well. And in order to keep the time frame, I will rely on my written notes. Because if I would not, then I'm afraid we would sit here until tomorrow, which is not the intent that I may say of the organizers and the colleagues. So, wow, thank you. So, to give you a kind of structure, as well of the presentation and also as well of the manuscript, which is designed and which is based on a more detailed explanation of how international law can serve the protection of minorities. And this is the only slide I have. The next one will say, thank you so much for your attention. So, okay. In Europe, the history of minority protection goes back centuries. Much further than the concrete historical events that gave rise to international human rights law, the protection of minorities today, which is closely linked to the protection of human rights, is, despite obvious failures, past failures, an upward process, the subject of increasingly effective legislation for the benefit of the groups of people to be protected. Thus, for example, the establishment and failure of the interval minority protection system under the auspice of the League of Nations in the 20th century was both a success and a failure. However, effective minority protection has been limited and raises many unresolved issues. For example, in the case of some communities, such as, for example, the Roma community. The protection of minorities is generally qualified as effective or less effective according to the extent to which civil and political rights are guaranteed, a rating that is much more nuanced for some minority communities and certainly requires a multi-directional approach. The development of effective legal protection for such minorities is not made easier by the fact that in their case the usual forms of discrimination are compounded by poverty, in some situations, by social exclusion, and a lack of effective education and training. Easier international movement of persons and migration for various purposes and in various forms also raises new aspects and difficulties in the legal framework for the protection of minorities. Effective minority rights protection, which is also in the interest of society as a whole, often becomes a serious economic issue in such a situation. With the increase in the number of international organizations directly or indirectly involved in the protection of human rights on the European continent, a kind of competition for fundamental rights has developed in recent decades. By widening the scope of the rights to be protected on the one hand, and by expanding the forms of legal remedies for their protection on the other, the organizations concerned are becoming increasingly integrated into the internal legal systems of the European states. This is why the shortcomings in the effective systematic protection of minority rights in Europe are quite obvious. In order to get a realistic picture of the current situation, it is worth reviewing the main stages in the development and evolution of minority rights. Minority rights are considered by international law scholars as an international norm with vague contours that are difficult to identify. Today, its content has become very broad and includes a large number of detailed legal provisions, yet its application reveals many shortcomings and raises many doubts. It is therefore a contradictory area of law, which needs to be examined in the light of the potential and obvious weaknesses of the existing minority rights, norms, and systems. There are tensions and contradictions at many points between the typically individualistic constitutional systems of our times and the concept of minority rights today. It is also clear, however, that is precisely the highly developed fundamental rights protection which has its roots, systems that are expected to protect the rights of minorities as well. The history of the development of minority rights protection, which has its roots in the distant past, provides ample examples of mistakes to be avoided and of the details to which particular attention should be paid in the course of regulation. The international protection of minority rights is much older than the international protection of human rights, the systematic protection of which was first developed within the framework of the United Nations. However, in the early period of the development of minority rights, the first forms of protection were already in place, mainly in the form of the fight against discrimination and the protection of religious minorities. Systematic protection of minorities first emerged at the beginning of the 20th century as a result of the peace negotiations following the First World War. The goal, according to the framers of the treaty system, would have been general political national assimilation, and treaty guarantees would have made the road to the goal possible and bearable. At that time, the dominant politicians of the time did not really have in mind a positive protection of minorities, but the potential of the treaties to pave the way for comprehensive assimilation. This kind of logic could even be seen as a kind of negative minority protection. The prominent politicians of the Allies, by making open and covert references, gave a voice to these expectations in 1919 and later as well in the interpretation of certain terms and concepts. As the texts of the minority treaty provisions were ready in May 1919, a new problem arose. The politicians of the Greek powers were confronted with the partly instinctive and partly conscious resistance of the states concerned, which considered the assumption of treaty obligations to protect minorities as a restriction of their sovereignty and an interference in their internal affairs, and tried to avert it. All the Central Eastern European states concerned expressed reservations and concerns about the draft treaties. Their opposition and rejection foreshadowed the reasons for the subsequent failure of the minority protection system. The peace conference at that time had created a unilateral system of a political nature without real sanctions. The failure was ultimately caused by the resistance of states to the protection of minorities guaranteed by the international law of that time. The complex political situation over minority and territorial issues after 1919 ultimately confirmed those who had reservations about the Treaty of Versailles. This also led to the term minority rights becoming a discredited term after the Second World War. After 1945, the issue of minority rights in Europe was taken off the agenda. The mass extermination of ethnic groups and the mass expulsion of other groups from their birthplace gave the false impression that special rules for the protection of minorities were no longer needed, or so the victorious powers thought. The protection of communities was relegated to the background, and the protection of individual rights, together with the individualistic concept of the protection of human rights under international law, came to the fore. However, the realization that fundamental human rights, and with them the rights of persons belonging to minorities, can only be understood in relation to the social embeddedness of the individual through social and cultural rights, and that human rights can only be exercised through membership of a community. See, right of association, right of assembly. And this was relatively quickly established. But there is a long way from recognition to implementation and the setting of a right balance. It is not easy to guarantee minority rights without the state concerned feeling that their national sovereignty is under threat. The situation was further complicated after 1945 by the relatively rapid onset of the Cold War. Some thoughts about the universal international level and the role of the United Nations. Everything else is written detailed in the manuscript. The role of the United Nations, despite the serious political doubts about the legal protection of minorities immediately after the Second World War, and not least due to the adoption of international treaties on general and specific human rights, a modest but nevertheless existing system of the general content of minority rights as substantive law and the mechanisms for their protection as formal law seems to take shape. At the beginning of the 21st century, the main aspects of international legal protection of minorities developed at the universal level are the following, some of the main aspects. I would enshrine that most of them, or many of them, are in the manuscript as well again. The first aspect is, which I think it is important to mention, that the protection of minorities is present in international law as part of the universal protection of human rights. Minority rights are individual rights. Their protection as collective rights is therefore enforced only indirectly, is the meaning of public international law at the moment. Another aspect is that it has long been debated whether Article 27 of the Covenant from 1966 is only capable of protecting persons belonging to minorities against discrimination, or whether it also includes a positive duty of protection incumbent on states. The latter interpretation is now the more common, in my opinion. In certain circumstances, states are also obliged to provide financial support for the exercise of minority rights. And one more aspect, the freedom to choose, which is one of the most important ones, I would say. The freedom to choose one's identity is a subjective criterion and a fundamental principle of belonging to a minority. Objective criteria can only be taken into account if belonging to a minority would be abused. As a general rule, a person cannot be denied the right to identify him or herself as belonging to a minority, which was stated in the Lovelace case, for example. To see what it happened at European level, of course, in short, nutshell. The idea of minority protection is rooted in the history of Europe. This is nothing new. The cultural framework and the ideological historical background for the protection of human rights is more homogeneous here than at the universal level. It is therefore possible to start from the assumption that there is a consensus at European level for a broader, stronger, and a more effective protection of human and minority rights than at universal level. The facts and the results support this assumption, even if the process by which Europe has reached the current level of protection of human and minority rights has not been smooth. Backsliding and restarting have been as much a part of this development as progress and stagnation, depending on historical events, domestic and foreign policy priorities, and even security policy circumstances. There is no time and space now for details, but the manuscript, as I have said, describes the most important elements and institutions of the protection at European level, including the OSCE, the Council of Europe, and the European Union as well. One element it is important, I think, to mention that in addition to the European Convention on Human Rights and its associated judicial remedies, the Council of Europe member states developed in the 1990s a set of hard-soft law instruments, mainly in the form of country reports, shadow reports, and monitoring procedures in the form of the European Charter for Regional or Minority Languages and the Framework Convention on Minority Rights. It is hard law because by signing international treaties, the signatory states have assumed real obligations, but due to the lack of an international judicial alternative of enforcement, these treaties have a merely soft law effect. However, that they have led to a strengthening of international public opinion and the role of domestic and international NGOs and to standardization of some minority rights. Great expectations have been placed on the role of the institutions of European integration in this area. In the early decades of the European community, it sought to avoid not only the question of minority protection, but even the question of fundamental rights. The reason for this was, to put it somewhat simplistically, the fact that the member states kept decision-making on human rights and, by extension, minority rights to themselves in this regard. They did not give the community legislative powers. However, from the 1990s onwards, European integration began to deepen. The creation of the Union was accompanied by a wide-ranging extension of competencies, including in fundamental rights matters. As a result of this development process, the member states of the European Union have recognized the need to enshrine the need for legal protection of minorities in the primary law of the Union and to establish certain indirect forms of protection at the level of principles. 20 years ago, one could not even dream of the current EU legal instruments of protection. The most relevant legal sources are listed in the manuscript. A wide range, now some concluding thoughts. A wide range, it is hard to skip many important things. A wide range of solutions can be found when looking at the ethnically heterogeneous states of the world. From explicit constitutional recognition to complete lack of recognition or even denial of recognition. There are diverse intermediate stages. Recognition by law or administrative act, recognition of private organizations representing minorities, and many others. The meaning of the term recognition varies from one state to another and may even vary from one period to another within a state. In some places, recognition means the legal personality granted to minorities, rarely, as evidence shows, such as in Hungary, for example. We have that. That is not have that possibility. In other states, members of minorities are granted rights which, taken as a whole, protect the existence and interests of the group. And in again other states, they are granted scattered rights which do not form a logical system. In what direction and with what content is state behavior sufficient for the existence of a minority, its culture and its use of language to survive and develop? This question has been asked for a long time by many people, with many different answers. International law has never been the law of nations, as a superficial analysis of the words might lead one to believe, but has always been the law of states, even though the right of peoples and nations to self-determination is an integral part of international law today, and despite the fact that, compared to the first half of the 20th century, the declaration and defense of human rights is a widely accepted phenomenon in the first years of the 21st century. Until recently, I got some doubts about that. Many doubts. European minorities, which with a few exceptions can also be fragments of nations, also be called fragments of nations, are as a rule not subjects to current norms of international law, but at best only beneficiaries. This was also the case at the time of the minority protection regime under the auspices of the League of Nations. The protection of minorities requires more than the mere application of the text of positive law. The psychological climate, the will that can be extracted from the general culture of the citizens, is of vital importance beyond the rules of positive law. With regards to minorities, the prohibition of discrimination and de facto equality go hand in hand with the prohibition of discrimination, as I have said. If a minority as a group is only guaranteed equal treatment action measures, which, by taking into account the specific characteristics of minorities, guarantee real equality. These compensatory measures are the very essence of the prohibition of discrimination in the constructive sense. In other words, the protection of minorities cannot be achieved by applying the principle of equal treatment alone, but it is certainly not possible to interpret it without that. The state can only be understood in conjunction with its minorities, regardless of space and time, said Bíró Gáspár at that time. The acceptable form of coexistence at any time is a dynamic series of mutual compromises. Neither side should sit back and relax. The task for state and minority is the same. The perpetual search for and maintenance of compromises is both an end and a never-ending process. It is the past and present legal environment of international law and, in particular, EU law, where we need to operate. It provides the universal and the regional framework for the everyday reality of each country's domestic law and, not least, their minority policy. Thank you for your kind attention. And if I may say a last word, not for my whole life, but if you are interested in how's the life of minorities living in Hungary at the moment, please use this QR code and you will get to the English homepage where you will find some concrete situations which we have to there in my office. Thank you again for